Afternoon. I wanted to greet you today and discuss the fact that today we're going to be presenting on some issues for you relating to liability and activities with regard to you performing within the course and scope of your duties. So with that, let me just jump in. You've seen the disclosures, and let's just hit that learning objective for today. We're going to talk about what liability, if any, a public school nurse has while performing your nursing responsibilities that are within the course and scope of your license, as well as within the course and scope of your job description or your duties for your public school employer. Now, it's really important that we're also going to talk a little bit about how not to step out of the lanes of 1 and 2, because staying within those lanes of 1 and 2 will keep you out of trouble. Keep you out of liability considerations. With that, I'm sorry, I'm having a little trouble moving to the next slide here. All right, so the key points is we're going to talk a little bit about personal liability versus district liability. Working for a public school district, generally speaking, every employee under something called the Idaho Tort Claims Act is an employee of the district, and you are protected from personal liability for your actions while you're working and while you're performing your duties for your employer, so long as they're within the scope of your license, within the scope of your job description, that you're not performing a crime or acting with malice, which quite frankly both of those would be out of the scope of your license and out of the scope of your job description, and when you're following the directives outlined in state and or federal law, rule, or regulation. So generally speaking, everything you do within the course and scope of your job as a school nurse, so long as you're acting as a school nurse, you're at school, you know what your job description is, you're acting within your license, your employer is responsible for anything that goes wrong with regard to liability. So hypothetically, something goes wrong, the school district gets sued. While you may be named in that lawsuit, it is the school district and its insurance company, or the charter school and its insurance company, that is going to pick up that liability and take care of that under their insurance policy. And as I had mentioned briefly earlier, that's all under the Idaho Tort Claims Act, which is a section of Idaho law. It's in Title VI, Chapter 9, that applies to all governmental entities in the state of Idaho. A public school district and a charter school would be considered public school entities under there. So looking specifically at Idaho Code Section 6-903, I've underlined the important parts there. Employees of every governmental entity, i.e. public schools, are subject to damages, which means they can be sued for events arising out of their negligent or wrongful acts or omissions, and those wrongful acts or omissions of its employees acting within the course and scope of their employment or duties. So that's why I say you have to stay within the parameters of your job responsibilities, your licensure, your job duties, etc. You are liable, or not you personally, but you being the district is liable to the same extent a private person would be liable for those same types of things. Now, there is a limitation or two on that, in that a governmental entity, and that includes the employees acting on behalf of the governmental entity, are only liable for the pro rata share of the total damages. So only the damages that a jury determines are caused by, in our case, the school district or the school employee, because there may be other people who also contributed to the cause. So we only pay for or are only responsible for our portion and our provision. We don't get stuck with the entirety of it. Sorry, this is a little bit small, but this is a continuation of part of that Tort Claims Act. This requires the governmental entity to provide a defense to its employees, which means a defense and indemnification, so that any liability that is found against or associated with that employee's actions are taken care of by the governmental entity. For any claim brought against the employee, even if it's in your individual capacity, when the claims are related to the course and scope of your employment, and they are responsible for the payment of any judgment or claim associated with money damages, therefore. So again, if in the course of acting as a school nurse, something happens, the school gets sued, you're named in that lawsuit. This is the provision of Idaho law that steps in and says, nope, school district is responsible. They have to step in and take care of the defense of it. And if there's any liability, that is on the school district and their insurance company to take care of, not the individual. Again, only the pro rata share, not the entirety. Now, if you see in the bottom there, subsection 3 is one of the exceptions. An entity, a school district, can refuse to defend in a situation where the act or omission is determined to be not within the course and scope of his employment, or if it includes malice or criminal intent. So if you remember my slide back 2 or 3 ago, there were those things: don't commit a crime, don't act with malice or criminal intent. The example that none of you will have occur in your career, but the example that we use that occurs is hypothetically saying if a school employee engages in a sexual relationship with a student. That is not within the course and scope of their employment. It is a criminal act. You are not advancing any purposes of your employer. So that is one of those situations where a governmental entity could say, nope, sorry, that is an individual situation for an employee. But we're never going to have that happen for any of you. They are not entitled, they being the school district and or its insurer, are not entitled for any indemnification or reimbursement for legal fees or expenses from you. Because of these provisions. Again, unless it is found that you have acted with outside the course and scope of your employment or acted with that criminal intent or malice. So it's that same issue coming up over and over. Now, the law itself has a presumption that you are acting within the course and scope of employment. So for somebody to say at a public entity that we're not going to cover an employee, you have to, the governmental entity has to overcome that presumption. So they have to be able to prove that, okay, yes, it was not within the course and scope of their employment. It was not for their employer. The sexual relationship example is the one that is always the cleanest black and white for that. Now, there are some definitions in the Tort Claims Act that we're just going to touch upon briefly. Gross negligence is a big one. So if it's something that is an action or omission that a reasonable person in a similar situation would do without even really thinking about it, that it's an obvious, it's a recognized thing to do, it could fall under that definition of gross negligence if you have failed to engage in that duty or have shown deliberate indifference to the consequences of harm to others. Reckless and willful and wanton conduct is another one that sometimes pops up. Again, that's intentionally and knowingly failing to do an act which causes harm to another person and involves a high degree of probability that that specific harm will occur. In your context as a nurse, doing nothing. As long as you are engaging in your nursing skills, and I get the do no harm. Obviously, if it's not within your licensure, that's one thing. If it's not within the course and scope of your duties, that is another thing. But if it's clearly within the course and scope of your duties and responsibilities, and you are intentionally and knowingly doing nothing, and you know that your doing nothing is going to cause a specific harm, it could fall into that category of reckless, willful, and wanton conduct. One other thing I did want to touch on in the the Tort Claims Act is there is a little provision in 6-917 that recovery against the governmental entity bars them from going against the individual as well for the same matter. So hypothetically speaking, a negligent act occurs, an omission to act occurs that results in a negligence and a finding against the school district. They can't then come file another lawsuit just against you as an individual. It's done, it's over, because that is part of the way that the process is set up to be handled. Now, when does immunity not apply? Well, it does not apply to reckless conduct or willful or wanton conduct. So if you're standing there, it is possible that an immunity does not apply to the governmental entity and or to you. Immunity also does not apply if there is an engagement in a crime. So the general rule is that we can be sued in the same nature as an individual. There are some specific exceptions that individuals cannot sue governmental entities for. One of them that I use a lot in my career is representing school districts is something called negligent supervision. So if student A gets into a fight with student B and they argue that it occurred because we weren't watching the kids close enough, believe it or not, we're immune from that. So there are a whole host of those types of things that apply in a school district context. None of them specifically fall into the parameters of nursing. It's just a big general of can we manage to get something to fit into one of those. Less and less do we see those applying. More often than not, we just see general negligence types of things. So those immunities would not apply, and those immunities would also not apply in these types of situations where we have gross negligent, reckless conduct, and criminal acts. Now, there are some immunities that I do want to touch on in the healthcare context. And the first one I want to touch upon is the Idaho Good Samaritan Protections and Immunity. That is not part of the Governmental Tort Claims Act. This is a general immunity that protects any person. You as a healthcare professional would be included in any person who in good faith stops at the scene of an accident and administers first aid or medical attention, so long as you're not grossly negligent. We already talked about what that definition of grossly negligent was. So long as you're not acting within that parameter, doing something or failing to do something which a reasonable person would do with a minimum contemplation and recognition that your failure to act would show deliberate indifference to the harmful consequences of others. You must act in good faith. If you're on district property, I would also say you need to comply with district protocols. What this does is it provides a civil and criminal immunity, and that immunity ends once the person, or immunity for the actions ends once the person is delivered to the hospital, EMT, assumption of responsibility, etc. So at that point in time, we're hands off. We no longer worry about Good Samaritan protections and immunity. Now, when you're on a school district property and you are providing emergency care, emergency first aid, or medical attention, you're going to be acting within the course and scope of your employment, so we're going to have that protection for you as an individual. We also have the Idaho Good Samaritan protection. We can argue. Where this could come up is somebody tells you that there is an accident down the street, and you're the closest healthcare professional nearby. Your job is not to leave the school and go take care of that situation. In all honesty, EMT is going to likely be there before you are anyway. So I would not advise you to exit your workplace to go take care of a car accident down the street. Now, if you are at school and it's after school hours and your day is done and there is an accident on the playground, yes, you're going to go out and you're going to take care of that child, and I'm going to argue on your behalf that yes, you are within the course and scope, and oh, by the way, even if you aren't, you have this Good Samaritan protection. So I'm going to make sure that you're covered one way or another on that. There are also some other immunities that we're going to talk about, or some protections, and drug overdose and Narcan. This is also a specific provision in Idaho Code. It's 372730 capital C. That it creates an immunity for individuals who act in good faith and exercise reasonable care to administer Narcan to someone experiencing a medical emergency due to an opioid overdose. And the statute creates immunity for the poke. Now, again, in a school setting, you are providing emergency first aid care. That's life and death kind of care. I would hope each of your districts has a protocol, and that you are well versed on that protocol, and that you are following that protocol for the possession, storing, use, administration, all of those types of situations associated with Narcan. So I would tell you to follow those. That is going to, again, put you under that umbrella of protection of the district for immunity, or excuse me, for liability. So if something does happen, the school district would get sued, and if you were involved in that, you would be covered, like we talked about earlier. Plus, there is this immunity for having administered Narcan. I do know we have had school districts in the state who have had to administer Narcan. I'm thinking of at least 3 off of the top of my head in the last 2 years. It is an unfortunate reality, and it's one of those things that you want to make sure you're well versed on and that you have protocols if your school district has approved possession and administering of Narcan. Now, another area where liability can exist is under the Family Educational Rights and Privacy Act, FERPA. We know that that is generally a federal law that protects and controls student educational records. So who has access to what, when, where, how, why, how things are documented, how they are changed. In general, student educational records are confidential and they are not to be shared with anyone who does not have a legitimate educational need to know. So the teacher may need to know. You as the nurse may need to know something in there. A teacher at a different building does not have a need to know. A parent who happens to be in the school does not have a need to know. I always joke that I think the number one place that FERPA is violated is in the teacher's lounge because everybody's in talking about what's happening with individual kids. So student health information that is maintained by the school district is more often than not a FERPA issue, not a HIPAA. HIPAA generally does not apply to school nurse records, but in all honesty, HIPAA has the same concept. It is also a confidentiality that could create a liability for disclosure. General rule to follow to keep you guys out of trouble: don't disclose any student health information unless the person you are disclosing it to has a legitimate educational need to know. It's to a parent, legal guardian, or pursuant to a subpoena or properly issued order that requires us to provide that information. Also, in medical emergency situations, there may be need to disclose as well. So if EMT is on the scene and we know that the student is a diabetic and they are in a particular state, yes. So you are going to have to treat those educational records in the same manner and protect that same confidentiality that you would if you were in a hospital protecting medical or HIPAA records. That is an area where liability can be created as well. Another area where liability can jump is our newer areas, our parental rights liability exposures. We have parental rights issues under Idaho Code 33-6001, and in all honesty, there's also the parental medical rights under the separate section, but given that we're in the educational context for today's discussion, we're going to stick to this one here. I have just hit upon a few things. Reasonable academic accommodations. So parents are to have knowledge about course of study and have the opportunity to review materials, including supplemental materials, that their child is going to be exposed to. A parent can remove their child from that. So if in your situation as a nursing professional for a school district, you are involved in some educational activities, be it maturation, development, medical or health issues, those are things that parents can have the right to have information about. They can see the materials, including supplemental materials. Depending upon the subject matter, they may have to sign off on it, which means you've got to stick pretty tight to what your curriculum and your script is. You also are part of the school district personnel that has a legal obligation to notify parents of known changes. And known changes is what I hit on. Not just, oh, this is the way the child is. Well, the parent already probably knows that. But if something has changed from your knowledge with regard to a student's mental, emotional, or physical health or well-being, you need to notify the parent. Most school districts have a process and a protocol of how that's done, whether that goes through you, whether that goes through counseling, whether that goes through the administration. Please, if it goes through you and or if you are consulting with others about it, please make sure you've documented that. A lot of times in emergency situations, The clarity of communication, the recollection of communication isn't necessarily as solid as we would like it to be. And parents aren't necessarily going to remember everything that they've heard when in those contexts, and I can understand that. Liability can also attach if there's classroom instruction on sexual orientation or gender identity in a manner that is not age or developmentally appropriate. Again, that is something that I have seen nurses have to be involved with in the educational context, but this is a curricular matter that make sure that your curriculum people are following, that your involvement in it is consistent with this law. And if you have any concerns when you're preparing for it and looking at the materials, that you have those discussions as well. A few other things on parental rights that could trip liability is making sure that you do that annual notification of the health services offered or made available through the school or by private organizations. So if you have somebody doing vision screening, dental screening, audiology screening, scoliosis screening, make sure that that's all included. We have to do that at the beginning of the year. Remember, that also includes specifically first aid in the statute. That's where that whole Band-Aid nightmare has come from. So that you make sure that those are disclosed and that they are only provided with parental consent. So making sure that those registration documents include that consent information, because I have had more than one situation already around the state where medical care was provided allegedly without consent, and that can trip some liability as well. Is surveys and screenings. Sometimes nursing gets involved in some healthcare surveys. Non-academic or non-curricular surveys are number 7 in parental rights. So if there's any request that includes, and in your world it would be sexuality, sex, psychological problems, mental problems, something like that, there is a proper protocol that has to be followed. Parents have to have notice. They have to have permission to approve it. So those are some of the big areas where, just from my experience, I see it. So let's just talk about some of the practical here. Document everything. The good, the bad, the ugly, whatever. I mean, we aren't making up stories. We live and die by what we did or did not do. I trust you all know what you're doing. I trust that your best interest is for the health and safety of students, and your records are going to show that. Even if it is not necessarily dotted every I of statute, your records are going to show that you did what you thought was best to care for a child. Of course, we're going to try to stay within the dotted I of statute, but those are the types of things. So please make sure you document everything you do with regard to the performance of your job duties. Assessing student condition and the actions that you take in assessment. Communications with parents. Like I said, sometimes in the heat of an emergency moment, they're not going to recall all the details. I don't expect them to recall all the details, but if you have documented, spoke with mom from what time to what time, these were the subject matters we covered. Parental consents. There's a lot of things, especially in that Parental Rights Act, that requires parental consent. We want that in writing from them to you. Email's fine. I do recognize that there are emergencies. If it is totally impossible for you to get written consent in an emergency situation, I can argue a recording. I can argue that you've recorded the conversation, including the permission, explain to the parent, I'm recording this, please, state whatever, that they are giving you authorization. That should be like a 1 in a million type situation, because you should be able to communicate at least by email and get that. Stay within the scope of your license. If you can't perform something that somebody is asking for you to do, just explain it. It's not within the scope of my license. Document that. You can make inquiry to the Board of Nursing. How do we deal with this? We're seeing a lot of these with more complex students that we have with special education, and requests being made that school districts take care of provision of healthcare services that are questionably nursing duties or not. So when in doubt, stop, ask, clarify. We can go to the Board of Nursing. We can go to the hospitals and ask, is this something even your emergency room nurses do, your ICU nurses do? Document that you're going through this process, who you've talked to, what you've asked, what they've said back. Please make sure you follow established protocols and that you actually have protocols. I know Tracy is available to help you guys if you don't have protocols. I know I've seen Tracy has protocols on everything known to man, which is wonderful. Have them, know them, follow them. In an emergency situation, have them handy if it's something that's really rare so you can go through it. Make sure you've read them in advance so that the first time you're looking at it isn't during the middle of an emergency. If you deviate from that protocol, obviously there's going to be more potential for liability and exposure. If you deviate from that protocol, you better be able to explain why. And there may be totally legitimate reasons why something was deviated from the protocol just because the factual circumstances didn't fit. Collaboration with your peers. In all honesty, rarely, if you go around the state, it's kind of amazing. A lot of the same things happen in schools. As I indicated, special ed is far more complex than it used to be. So if you're being asked to do something that under a special ed umbrella that makes you uncomfortable, reach out and talk to your peers. See what they've done. See what alternatives they have come up with. Next one, I've already chatted about it, making sure you have established written protocols, that you've practiced those, that you have them accessible when something goes down. And I mean that literally. I know of an experience recently where the power went out at a school building, which took out some of the computer systems. How are you going to access your protocols if you can't get into a computer system? How are you going to access certain directions and directives and statuses of students if you can't get into your computer system? Think that through. Have a backup way to address it. Even if it's calling the school across town and they can get into the system, making sure that can be taken care of. Administering of medications, again, a big practical that can be liability situations, only with proper authorization and documentation. Only as prescribed. Do not independently follow the direction of mom or dad saying, oh no, we don't follow the bottle directions. This is what we do. If that's what you're told, it's time to go back and clarify with the healthcare provider, you and the parent and the healthcare provider, what is the prescription? How is this to be provided? If they want you to do something differently than what is prescribed, have the new prescription done. Make sure it's securely stored. Make sure it's up to date, not expired. Please make sure you have, maintain, and preserve accurate logs. When it's accessed, who accessed it, was it dosage given, all of those things. Okay. We're coming to a close here. Liability, just make sure under the rules and regulations, just to summarize, that's the district's responsibility. Under Idaho Code, if you are within the course and scope, if you are not criminally acting, you are likely going to fall within the protection and prerombums of the district's liability. Now, as far as under your licensure, that will typically be a private matter between your licensure entity and yourself if something goes wrong. But again, that's not a criminal liability, that's a licensure issue. Under the Nursing Practices Act, delegation and training, make sure that you're comfortable and aware of that when you are delegating and training other staff members to perform duties that may be something that would typically be performed by you. I know in some areas that our nursing opportunities at buildings can be slim. So if you are delegating nursing responsibilities, please make sure you've engaged in supervision, that you've engaged in monitoring, that you're making sure that your delegation and training follows the Nursing Practices Act, and that everybody is comfortable with that. There may be things that you cannot delegate. That is a reality, and I understand that is a cost for school districts. Unfortunately, it's more often than not in a special ed context with high need students versus providing a student with a medication pill at 2 o'clock every day. Nursing standard of care. Please think that through in each of your protocols and in each of your actions, because if you're operating within your standard of care, the possibility of being liable is so much less. So what would another nurse in a similar situation do? If you go back 2 or 3 slides, we did talk about your collaboration, following, similar protocols, similar procedures. You've communicated and you've collaborated. So if something were to occur and somebody says, well, why did you do it that way? Well, in the 18, school nurses that we talked at this conference, or we were trained at, or these districts all have the same protocols, and we've talked them through and worked them through. You're sort of creating your own standard of care and your own standard of practice, consistent with your professional standard of care and practice in the school setting. So make sure that that is something that you look at. Just a few last things in closing. The do not volunteer to testify. This is not a nursing thing. This is something I share with every school employee. Parents like to chat with and hope that those people in a school building who love their children will stay actively involved. It's one thing to be subpoenaed to testify. It's another thing to volunteer to testify. I advise all school personnel to never volunteer to testify. Couple reasons for that. One, truly, it's not your job. Your job is to take care of the kid in the school setting. 2, once you have agreed to testify, you have picked a side. I have agreed to testify for mom. Okay, the likelihood of mom having sole custody of this child for the remainder of this child's life is very, very low. You have just created an enemy out of dad, somebody that you and or the entire school system will have to deal with for the rest of the child's experience at the school. While you think you may be in good faith doing what's right for the child, in the long run you may not be, and you may be damaging that child's relationship with the entire school system because you cannot work professionally with both parents. The last little bit on never volunteering to testify is a tiny slice of that child's life. In a nursing context, even a frequent flyer in your office, you may see a couple hours a week. You only know what the child is telling you, which may or may not be true. I'm going to take the child at face value, but 3 hours of their week. If you are subpoenaed to testify, of course you're going to talk about those 3 hours. You're going to be honest. You're going to be truthful. You're going to be forthcoming. But you're not going to volunteer to go in and testify and assume that 3 hours is what their entire life is. So I have absolutely no problem with a school employee being subpoenaed to testify. I probably prepare 5 people a week to go in to testify. It's more often than not in custody matters. Sometimes it's in juvenile criminal matters. But when you volunteer, it creates unintended consequences. My last bit of advice, and this is also something I share with school employees, you don't get out of a lawsuit or you don't get out of liability by doing nothing, by avoiding student interaction or engagement or just sitting silent. As part of an educational team, you are on the team for a reason. So if you are part of a special ed team and they are asking you your opinions and your information, you provide it. You don't sit silent thinking that these are litigious parents, and if I start sharing information, we're going to end up in a lawsuit. I'm going to end up testifying. Those types of things. No. Remember that deliberate indifference definition that we talked about earlier on? The willful, wanton, and negligent conduct by basically doing nothing when you know nothing can cause harm. So you do your job. You follow your professional practice, you follow your job description, you stay within the course of your responsibilities, and we take care of kids. With that, I did offer to answer any questions that come in written. The first one I actually answered directly with the school district, so I will just cover that here. And that question was, if you have parents with who are split, and still have joint custody to make decisions, and one parent wants a child on a medication and the other doesn't, what do you do? First off, we don't go looking for parent dispute on medication. We don't go looking for parent dispute on medication if the parents are together or if the parents are apart. If you have received information that you are to administer an ADD, ADHD medication at noon every day, that is what you do. so long as you've dotted your I's and gone through your protocol that you have at your school district. You don't go out and ask, is the other parent in agreement? We don't do that for anything in education unless there is some bizarre specific court order that requires us to do that. And if there is, you will know about it. However, if you become aware of the fact that a parent disagrees, then we stop, because we do not have agreement between the two parents. We aren't the decision maker. We don't interpret who has that final say. They need to figure that out. So if you become aware of that, we are not administering until we have further direction. You get your admin involved. You may get your district legal counsel involved, and we figure it out. But we don't go looking for that problem. And quite frankly, that should be part of your protocols for administration of medication. And it isn't just divorced parents where we have that difference. We also sometimes see that difference even on parents that are in the same household. So if you guys have any other questions, please feel free to get those into Jocelyn, and we will get them answered. I hope you have a great holiday, and I look forward to the next time we meet. Thank you.